Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every single Sunday from 8 to 9 a.m. on these stations to bring you, the landowner, the valuable information that you need regarding natural gas developments here in Pennsylvania. If you are looking for landowner information, well, then this is the show for you. At the Clark Law Firm, I focus solely on landowner, and you hear this often, landowner word, but focus solely on landowner representation. I do not, will not, have not, and will not in the future represent gas or pipeline companies. I represent landowners and oil and gas right owners for such things as oil and gas lease negotiations, reviews, consultations, pipeline and water line agreements. I've done negotiated pipeline agreements with over 50 separate companies in Pennsylvania. And I say that to give a background of the experience and also, what's going on out there so you know who you're listening to. I don't say it in an attempt to be some kind of pompous individual. I say it to make sure that people understand, I'm out here. I want to try to communicate. I want to try to give you good quality information and have an idea of what it's based on, not negotiating a couple agreements here or there or reviewing a couple agreements, but literally being in the pits. I say, out there negotiating day in and day out on behalf of landowners, reviewing documents, oil and gas lease amendments and modifications. Been doing those, have become a little hotter recently. Been doing more of those with various companies, doing more with estate planning issues. One of the things, I've been doing reviews with clients with the proposed settlement with Chesapeake, and in that process, it's sad. There's been a couple people, a couple families who, I have new clients, I have older clients, and people I've represented for a while. And one thing I've found just recently, where a couple families that have been good clients over years, first with the gas lease, then pipelines, and now with settlement related issues. And an interesting thing, sadly, had three brothers who represented again for a long time, who owned the parcel, and now they're not speaking, which you hate to see those things. There's another family, same thing. The siblings aren't speaking at this time, and it used to not be the case. And what we found is, like all of these people individually, but what we found is that these rifts or the problems actually stemmed from when their parents had passed away, that the way the estate plan was set up or how people handled the estate plan created these huge problems within the family. So, whether, I say it often and I do mean it, whether it's me or somebody else, make sure that you get an estate plan in place that you're comfortable with for you, not your neighbor, not the guy down the street, but for you. And make sure that you have it set up to try to avoid these type of issues. I have two sons. I can't imagine when I pass away that they end up not speaking because I didn't do a good job. And look, you can't control everything, but I want to make sure that I do a good job in avoiding that with my estate plan, to say, hey, look, I don't want you guys fighting over everything. And a lot of that's communication. And look, it doesn't happen often, but I will say that I think that some of these problems could be avoided with proper estate planning and direction to avoid this confusion or arguments among siblings and children. So it just, I hate to see it. I really hate to see it. So it's important, don't leave this stuff open and think, okay, well, they'll figure it out later on when I'm gone. Because you can end up, the children, which, you may never have thought there could be a problem, ends up being a problem. So, it's a little side, but estate planning is important for many, many reasons. And sometimes I guess people don't think about all of the reasons. So whether you call me, whether you call anybody, make sure you got a plan in place, that you have clear directives of what you want to occur upon your passing, upon your death, and make sure that you communicate. I think it's an important thing to communicate with your children, but again, that's a personal situation for everybody. Also, back to at the Clark Law Firm, we deal with surface use agreements, of course, pipeline agreements, meter sites, compressor station agreements, storage agreements, doing a lot of work with the Atlantic Sunrise project for clients, and other FERC Tennessee line extending the Sunoco line, Penn East, Mariner, doing a lot of work with those projects as well. So anything related to natural gas, you can contact the office 570-307-0702, 570-307-0702. Talk, we'll do an intake, see if we may be right for you. I'm going to real quick, because I've been saying this, especially in these FERC lines, but look, with any of these things, I've been doing more with all types of different agreements, these initial consultation and reviews. So you have this consultation, you have a review, you walk out of it with a much better understanding of what your options are and what you're able to do. And then you decide. In a lot of cases, you may decide, hey, look, you know what? I'm not interested in pursuing this offer. I don't have to. I didn't realize that. And so I'm going to politely decline and move on. Or you may say, wow, I'm interested in this offer, but I didn't realize that I could negotiate compensation where I could potentially get significantly more money. You have to understand every scenario. And generally speaking, in virtually every case that I've ever worked on, we've been able to improve agreements by the language or the words, literally the words in the agreement, to make them more landowner friendly. So even to do an initial intake, review, consultation, get up to speed and decide, hey, how do I want to handle things? That's worked very well with all kinds of projects, but exceptionally well with the pipeline and the FERC projects like the Atlantic Sunrise, those type of projects. Also, and I'm going to talk some about oil and gas rights and selling or considering selling your oil and gas rights. I mean, there's not a big enough stump for me to get on to talk about that issue. I'm almost begging people, not because I want the business, I don't mind the business, but you need to speak with somebody before you make any commitments to sell your oil and gas rights, your mineral rights, to sell your royalty rights, to assign your lease to one of these companies or third parties. If you're going to engage, we're doing a lot more with real estate transactions and deeds. I mean, I'm left scratching my head so many times where we see deeds. Somebody says, hey, will you look at this deed? This lawyer drew up this deed. Will you look at this deed? And they tell us what they want to do with the oil and gas rights. And the language just doesn't say what they think it says, or what they want it to say, I should say. I mean, they can read the language, but it's not saying what they want it to say. And, I say, going back in time, I say this to my sons all the time, nothing is a problem until it's a problem. And, going back and forth with my son on that, he as a 20-year-old, now he's 20, he was a little younger before, and you're butting heads, and he says, Dad, that's a really stupid thing to say. Of course, nothing is a problem until it's a problem. But I still maintain that fact that there's no problems until there's a problem. So if you sign a bad agreement, and say that agreement expires and it goes away. And I had this the other day. These guys, they had signed a pipeline agreement with Cabot, which is probably the worst pipeline agreement that I've ever seen. Probably, in modern times, like after the year 2000, probably the worst. Thankfully, it's not out there anymore, but there was a period of time where Cabot was presenting pipeline right-of-way agreements to landowners, and they had like a 7-year option term, 7 or 9, but we'll go conservative and say 7, and they were paying them, I think like $20 a rod, meaning $20 for every 16 and a half feet of pipeline, so obviously next to nothing, no location, wide open, just the worst of the worst type of agreements. And what's happened is I had a guy the other day called me, said, hey, I have a pipeline offer. I think it was from Williams. And we went back, sent me all the information. We did a little work and said, oh, wow, this gentleman had signed this really bad Cabot pipeline agreement. But he signed it so long ago, like over 7 years ago, that agreement has actually expired now. And it's like where you wipe your brow, wipe your forehead and say, whew, thank heavens, because it was a terrible, terrible agreement. So my first question is, hey, did they pay you anything under this? Did they do anything to exercise this? And again, wipe your brow, thankfully, no. So in that case, the gentleman signed a very, very bad agreement. It could have been really, really bad for him, because it could have had this very long pipeline going across a very nice piece of property and literally be paid next to nothing. And the company have the right to come back, put future lines in, additional lines, above ground structures, widen things. I mean, it was really a bad agreement. So in that case, that gentleman signed an agreement, a horrible agreement. He got, in my opinion, very lucky that nothing happened over those 7 years, and that expired. So there you go. Great example. Signed a bad agreement, no problem. Nothing's a problem until it's a problem. So that guy, hey, again, wipe your brow, lesson learned, move on. However, you take another gentleman I had, a couple years ago, who signed that same agreement, and now the pipeline company and a new company comes and says, hey, and I think it was again Williams, says, hey, we want to do a pipeline agreement on your property. Guy says, I really don't want this, and the lease doesn't allow this pipeline. I really don't want it. So what happens is he says, hey, thank you, but no thank you. And what do? They pull out the old Cabot easement agreement that he signed. It had a 7-year option term, and said, well, if you don't agree to a new agreement, Cabot will or has assigned these rights to us, and so we can use, we believe, this old agreement. Well, nothing's a problem until it's a problem. And now it's a problem, because now if you don't agree to enter into another agreement, at worst, the second company says, okay, we're going to use this agreement that's been assigned to us that you signed years ago. We're going to pay you literally $20 for every 16 and a half feet of pipeline installed, which is crazy, but you signed the agreement. So that's a problem. Then also, if you say, well, no, I don't think that's valid, the company says, well, yes, it is valid, and we're going to do this, try to stop us. Again, now you have a problem. Well, what do you do there? Most people are probably going to say, okay, and most lawyers who know what they're doing is probably going to say, all right, well, look, I'm probably not going to get into a fight in this situation with the company. It's going to be cost prohibitive, and we're not going to do that. So let's do this. Let's work to get an agreement that the old pipeline agreement will be released or given up. So we're not going to have that in play anymore, and enter into a new pipeline agreement with the second company. However, leverage, our leverage on the landowner side, to say is substantially diminished is not to say very much. It's really bad. We'll call it really, really bad. So what do we do then? We do everything we can. We get the best agreement that we can. We maximize the compensation that we can, and we get in, we get out efficiently and do the best we can. But in that case, that landowner had a problem, and that problem occurred because they signed a bad agreement originally. And had they talked to any attorney who knew, anything, they would have said, I hope, do not sign that agreement. That is a terrible, terrible agreement. And there's a lot of those out there. And I'll say this to my friends out there. Look, in my opinion, not specific advice for any single individual, I think that the Howard Energy agreement out in Tioga County is, again, one of the worst agreements that I've ever dealt with in working with 50-plus pipeline companies. Okay, I'll leave it there. You're listening to All Things Marcellus with me, attorney Doug Clark. And when I say I'm leaving it there, don't worry, I'm going to be right back after this break. Stay tuned, because I have 3 more segments left in today's show. Welcome back to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm, and I am here every Sunday from 8 to 9 a.m. on these stations. Been doing this show since August of 2010, so we are well over, I guess, at this point, 5 years. And I represent landowners, again, only landowners all across the state. Several clients right now in the southwestern portion of the state, clients all over the state, and again, people located all over the country. So if you are in need of representation or looking for representation or want more information, contact us. You can call the office, 570-307-0702. That's 570-307-0702. And no matter what, check out pagasleaseattorney.com. Our websites, pagasleaseattorney.com, pipelineattorney.com. You can go, you can listen to, we have the shows archived, we index them. Today's show will be up tomorrow morning. You can go and listen to today's show, any other show, dating back, I think we have them about a year or so back now on the websites. We want to keep the shows stale, we don't want to keep them stale. We want to keep them fresh. We want to not have stale shows posted up on the website. So you can go check out the websites. We're talking about certain issues today. We talk about many other issues. I'm talking about a lot with royalties and deductions recently. Check out, you can go hear last week's show, a couple weeks ago, same thing. Many shows on pipelines, leasing, modification, and amendments. So no matter what you're interested in, there's a really good chance there's a radio show on pagasleaseattorney.com or pipelineattorney.com that's going to be informative for you, and not just the radio shows. A lot of great landowner information, education, frequently asked questions, common landowner mistakes. Go check it out. Check out the blogs. Really think, I guess I'm a bit biased, but I really think that it's a good place to get good quality information. We're proud of the sites and encourage you again to go check them out. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I was talking the first segment about, nothing's a problem until it's a problem. And I was saying a bit how I've been preaching that to my kids for years. And I think, I hope, but I think it's sinking in. But the same thing with landowners. You can sign a bad agreement and you may never have a problem. Or you can sign a bad agreement and find that it comes back to bite you over and over and over again. And I see that often, more than most, because if everything goes great, there's no reason to call me. But if there's a problem, then people may give me a call or some other attorney to see if you can correct, fix, stop, do whatever we got to do to make this a better situation. Correct the issue if possible. Unfortunately, too many times the answer is, I shouldn't say too many times, but it's always disturbing when the answer is, well, unfortunately, you signed this really bad agreement whenever you did, whether it be a lease or a pipeline agreement, surface site agreement, whatever the case may be. And because you signed it and because you agreed to the things that you agreed to, the company actually has the ability to do what they're doing now. So there's nothing that I'm going to be able to do to stop that. So I hate to tell you, but unfortunately, that bad first agreement is coming back to haunt you. And again, I see that all the time. And I talked recently about that with a client that signed a surface site agreement. And what's disturbing is, in that case, I had represented them for a pipeline agreement in the past, had a great agreement. Company comes out and says, we want to do a surface site. We'll give you the same terms that you had with your pipeline agreement. We'll make this real quick and easy. You don't even need an attorney. Well, very misleading, because your pipeline terms and your surface site terms that you need or language that you need aren't the same. You're not talking about the same thing there. And so, some of the terms were the same. They got good indemnification language, things like that. But the agreement had no restriction on size. And so now the company keeps expanding it. And the landowner is not very happy. But the problem is they signed a bad agreement. And they're not very happy. But they've signed it. And I wish we would have talked before. Could have said, hey, here's what the concerns are. But I'll tell you, sometimes that's not always even enough. I had a client the other day, within the last couple of weeks, called and sent me. He had an electrical easement for the property, and he says, hey, the company wants me to sign this easement. And I said, well, okay, what's the history here? Well, this person had signed a cathodic protection agreement to allow to have cathodic protection equipment on their property. This, again, was a client of mine in the past. So I thought, boy, this is weird. I got a copy of the cathodic protection agreement. I said, this isn't something that, I would have worked on or I would have ever recommended or suggested a client sign. So I went back and looked, and actually we had some communication, and I had told this individual, hey, I don't know that I would, there was a general discussion of, hey, what do you think about this? And my answer was, I don't really like it. You're not being offered a lot of money. Here are all these different potential problems that you may run into in the future. And, it's not about what the landman tells you that the company is going to do. It's about what the document allows the company to do. It doesn't get more basic than this. If a landman says, all we're going to do is blank. So that's all the company is going to do. All we're going to do is put this little single pool with a little box, and we're going to do that right here in this area. Okay, great. If you're good with that, landowner, no problem. Well, what do we want to do? We want to just have language in there that says the company is allowed to, and we won't be so specific, but it may say like one above ground utility pole and whatever wires or not or whatever in this particular area. Well, obviously there would have to be wires, but in this particular area. So, okay, if the company says, well, no, we need to have a 50 by 50 work area, and we can't limit this to just one above ground utility pole. So what does that mean? Well, that means that they may do something different. And if they only use one pole and you're okay with that and that works out great, hey, that's wonderful. But if all of a sudden you got all these above ground wires and poles and other structures in a 50 by 50 foot area, well, what are you going to do about it? You can't go back and say, well, the landman told me you weren't going to do this, because check your agreements. They all, virtually every one of them, have language saying that, look, if it's not written in this agreement, it doesn't count, essentially. Meaning, and some of them will go so far as saying, hey, look, the representative who communicated with you in the execution of this document and negotiation of this document doesn't have the authority to go beyond the terms of what are in this document. So you got to look at what's in the document. Many people are getting bitten by bad agreements that they signed in the past. So you got to watch out for that. And it's happening all the time. It continues to happen. And where does it happen most? Well, in places where there's been a lot of activity and there's been a lot of leasing, like Susquehanna County, Bradford County, the people there have had a lot of experience with this, and people have gotten burned, whether it be them, their friends, their neighbors, their relatives, people that they know in some fashion. Those people have been burned. So everybody becomes smarter. The whole idea, you're a little kid, you touch the stovetop, you get burned, you say, not going to keep doing that again. Before you touched it, you may not have realized it was hot. Same thing with these agreements. Before you sign the agreement and before you ever entered into this process, you had no experience. Then you go ahead, you do it, and say you sign up gas lease at 12.5% and a couple $100, and a landman said it'll never go higher. Or maybe you signed at $2,000 per acre and 15%. Landman said it'll never go higher. And the next month it goes to $5,000, 20%. You learn. Look, here it comes. The landman works for the company, not you, the landowner. So what are they trying to do? Get you to sign the document. What should you be doing? If this is your first experience, and I don't care if it's your 10th experience, I said earlier, I've negotiated in pipeline agreements with over 50 separate companies. I still learn things. I still have experiences that I learned from. So if you just simply negotiated one pipeline agreement, or your neighbor did, that doesn't even mean that that's a good agreement. So if you're basing the next thing that you do off of a bad agreement, what are you going to have? Now you have 2 bad agreements. So you definitely need to get someone who has the experience that can assist you, because these things can and do come back to bite people all the time. I've talked recently about clients that have this 1935 pipeline easement where the company says, okay, here, we're sending you this check for a very little amount of money, and we're going to put a pipeline, and it's going to be very close to your house, very close, because that's where our existing easement is from 1935, and we have the ability to put other pipelines in. Well, learn from these things. Whether it's 1935, I deal with 1950 agreements all the time, especially in Susquehanna County. We can learn from these things. And so you as a landowner, you've never dealt with these issues, most people, and you should get somebody who has that can help you, because we want to avoid those issues in the future. Just as simply as excluding 2 lines can generate hundreds of thousands of dollars for the landowner in certain circumstances. So you need to limit them. And when you talk to the landman, who again is working for the company, he or she is saying, "Well, the company won't do this or they won't do that." You got to understand, if they say something to you and you just take it as true and you don't test it or you don't find out, well, in that particular issue, they've won. You say, "Oh, okay, well, that's the case." Well, just because somebody says something doesn't mean it's true. Think back. The landman has said, these prices will never go up. We're never going to give anyone anything higher than this. Even the same thing with pipelines. This is all we pay. We're never giving anyone anything higher than this. Well, it turns out that virtually that's never true. In my experience, virtually that's never true. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So what I was saying is, you have areas, especially areas that aren't seeing a lot of development or haven't seen a lot of aggressive development. And greatest example that I can think of in the northern part of the state is Tioga County. And what we have is people who have not dealt with this or have not had these offers in the past are getting terrible offers, in my opinion, and people are signing them. And look, you can sign whatever you want, and nothing stops anyone from signing a bad agreement except education and information. That's what stops you from signing a bad agreement. Get educated, get information. You can go to message boards, but be very careful. I can't even go there anymore because, I've talked before about my blood pressure. It was just skyrocket to the moon because a lot of times the things on these message boards are just totally incorrect. They can certainly, who knows who they are saying them. They can be landmen. Oh boy. All right. I'm going to calm down. Okay. So we need to make sure that you as the landowner are getting good quality information from somebody whose agenda and motivation is to help you, and somebody who has the knowledge and experience to help you. We don't want you as a landowner basing decisions on what the landman tells you. They work for the company. How many landowners do we need to have touch the hot stove before they say, "Hey, I'm not going to do that again. I'm going to get some information." And like I say, even if it is just get a consultation and review, understand your circumstances, because I'm going to tell you, they're not going to tell you. They're not going to tell you if you have anything in your favor. It's not going to happen. You need to learn this on your own. And I don't care if your neighbor did an agreement, negotiated the agreement, or they know a lot about the gas industry. I've been doing this stuff now, 7 years, 8 years. I never lost track. Like doing these negotiations every day, and I still learn things. I'm still getting better. So the idea in dealing with 50 plus pipeline companies, a bunch of different gas companies, hundreds of leases, modifications, all of these different things, I'm still learning. I'm still getting better. And so you as the landowner, be careful if you're going to rely on your neighbor, because again, we don't know what your neighbor signed. Get good quality information for you and your circumstances. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm going to be right back after this break. And remember, I'm here every Sunday on these stations from 8 to 9 a.m. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, you can always contact my office at 570-307-0702. Just to wrap something up, I was talking about, I had a client who he executed this agreement for cathodic protection. Now the company comes back and says, we need you to sign this new easement agreement with the electric company. Landowner's not crazy about doing it, but they put themselves in a really tough spot. So all the things, and I hate to say this isn't about like an I told you so or I'm so smart. It's about that you can foresee some of these potential problems if you have experience and you've seen it before. And said, hey, look, I don't know that this is worth this money. Here are the different things that can come up and can be a problem. Just, I wouldn't do it. I don't recommend that you do it, but that's your call. It's your property, your call. They went ahead and do it. Here it comes a year or two later. All of these problems that I said, hey, watch out for, have now happened. Again, doesn't always happen. I'm not the smartest guy in the world. I'm not saying this to say I told you so. I'm saying that we can see and foresee potential problems. And if you know about those problems and you understand that these have occurred before to other people, you may not be willing to sign a particular agreement you're asked to sign. So we got to understand that. And this guy decided, okay, well, this company landman making a nice little pitch here, hardly going to be anything, pick up a couple bucks here. Well, now it's a total different situation. It's not what was orally or verbally represented to the person. And now they're in a pinch because now they're looking to sign and being asked to sign an electrical easement, which isn't restrictive, is very wide open. The electric company doesn't want to change and will not change their agreement. And it's a mini nightmare for this person. And it could have all been avoided. So again, what happened there? We didn't have a lengthy discussion. I didn't have a consult and review, just had a very brief little exchange and said, hey, I wouldn't even consider this if I were you. Everyone's entitled to do what they want to do. They considered it, entered into it. Now it's a problem. And it's something, too, that could have potentially been avoided had either, number one, you say no, or you do a better agreement. So just be careful. Just be careful. Go around, ask the landowners in Susquehanna, Bradford, Wyoming, ask them how many of the landmen that they were dealing with that got them to sign their lease or pipeline agreement. How many of those guys are they still dealing with my Pittsburgh accent, still dealing with at this time? These guys, most of them are long gone. They're somewhere else working for a different company. I love this. I used to get this a lot more. Landman says, oh, yeah, I'm working for this company, best company I ever worked for. Oh, they're so great. I'm working for them because this, I left this other company because, I didn't like the way they treated landowners. I didn't think they did a good job. This company's the best one I've ever worked for. I'll bet anything that was the same line that they were saying the last time. So, again, please be careful. Get assistance. You can contact us. You can contact somebody. Get good quality assistance. Don't put your name on the paper. Get quality assistance. Had a guy recently who doesn't even have a gas lease who's presented with a pipeline agreement for a terrible, in my opinion, terrible pipeline agreement. No rights in the world to put the pipeline on the property unless you truly don't care about anything. In my mind, again, in my opinion, why would you consider this unless it was going to be justified by compensation? Don't fall into these traps. I mean, these tricks have been employed for decades upon decades. Understand your rights. Really think about this and say, okay, why will I do this? And if you're going to do it, look, I make a living by negotiating and representing landowners in contracts and oil and gas related issues. So if everybody in the state quit signing agreements, well, I better go find something else to do, which I'll do. But the truth is what we want to do is have people who have good agreements, fair market price agreements to go ahead, who want to do it, who understand the pros and the cons, the goods and the bads, understand those things. And then, let's go ahead and we got a good agreement. You understand everything. Let's do it. But don't enter into terrible agreements when you don't have to. Don't enter into terrible agreements when you don't have to. Do not, I can't say this enough, do not be afraid to pick up the phone, call my office, 570-307-0702, or call someone else's office who's experienced, who understands these issues. Make sure it's somebody that has the experience to help you. Make sure, but do something. Do not just go putting pen to paper. Don't be afraid to call. Don't be afraid to call. Go check out the websites, our websites, pagasleaseattorney.com, pipelineattorney.com. Check out the testimonials there. Again, whether that leads you to call me or call somebody else, just see what's happened and how we've been able to help people. And I'm sure other good attorneys, and I do consider myself a good attorney. I work my butt off. I do the best I can for my clients. Find somebody like that who's going to work for you, who understands what they're doing, and you'll do better. Please don't rely on the company, and it's still happening. I'm going to let this go. I'm going to move on and going to talk about something else. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, check out pagasleaseattorney.com, pipelineattorney.com. Whether you're looking for representation or not, you can listen to today's show and many, many, many other shows at pagasleaseattorney.com and pipelineattorney.com. Okay, switching gears. I'm going to go calm again. I want to talk about things come up during every week and things, and I have this master list and I write down these radio show ideas. Well, something came up that I don't think that I've seen before, and I'll tell you, it's a Western Pennsylvania lease from Huntley and Huntley, Huntley, Huntley and Huntley Energy Corporation. So clients offered lease. I do a lot of lease work in the western part of the state. A lot of it, all over the state, but the western part of the state is very active at this time. I said last week, one of the highest, well, no, not one of the highest offer I've ever had offered on a per acre basis to any client ever is pending right now that we're about to wrap up probably in this coming week. Gives you an idea. This is still going on. Also, hey, gas prices, we can hardly offer anything. You go up to Tioga, listen to Shell is saying, oh, the gas prices are so low, we can't offer any money, and we need a 10-year lease, we want a 10-year option. Okay, well, over those 10 years, gas prices may go up. So if the gas prices are $1 an MCF or a unit today, and they go up to $5 in 5 years from now, are you going to give me anything further? Well, of course not. But you want me to sign a 10-year lease today at the lowest possible royalty rates with deductions. You want me to sign that today based upon low gas prices. Well, maybe, this isn't advice for anyone, but maybe instead of signing a commitment of 10 years today, maybe I wait a little bit and see what happens with gas prices. Maybe I do that, but everybody is in a different situation. We got to look at it. Got to look at your situation. But just the point to be looking at about the gas prices. Okay, I want to get back to the Huntley and Huntley gas lease issue. So one of the things I've talked a lot about is buying or selling, especially selling, your oil and gas rights, royalty interests. Can't say enough, got to be super careful. If you are considering selling your oil and gas rights, I'm going to say commercial alert, call my office, 570-307-0702. I don't care where you are. If you are considering selling your Pennsylvania oil and gas rights, minerals, royalty interests, call my office. If you're seriously considering this, have a review consultation. Let's talk before you make that next step, because there are so many pitfalls and things you need to know. You can call us 570-307-0702. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I want to talk about this Huntley and Huntley lease provision, which I find to be myself very concerning, something that I'm concerned about. So what does it say? Well, within the lease, buried within the lease, there's a segment referred to as preferential right to purchase. Preferential right to purchase. And what this says is, in the event that the landowner, during the term of the lease, or within 1 year of the termination of the gas lease, receives a bona fide offer in which the landowner is willing to accept from any party, not just a company, from any party, offering to pay the landowner for either an oil and gas lease. So if you're offered another lease during the lease or within a year afterwards, then that's part of this. And then also, or if you have an offer to purchase covering any or all royalties or any or all of the oil and gas associated with the lease premises. So if you have an offer for a new lease, well, you have your current lease out there. So you have an active lease. You get a top lease offer. This part of it. Or, and this is what really concerns me, or if you have an offer to purchase any or all of your royalties or oil and gas rights associated with your property, then here's the part. So if you have an offer for a lease or an offer to buy or sell your oil and gas rights, all or in part, you as the landowner agrees to notify the gas company who holds your lease in writing of said offer immediately, including in the notice the name and the address of the offeror, meaning who's making you this offer, the price that you're being offered, and all other pertinent terms and conditions of the offer. So what is this? This is what we call a right of first refusal. Very common that we see in leases, a right of first refusal, that during the period of time that you have a gas lease, if another company offers you a gas lease, you have to go back to the company that holds your current lease and say, hey, current company, I got an offer from another company that I'm interested in, and they're offering me blank, whatever those terms are. And you have to give that first company that now holds your lease the option to match that. And they could then take a new lease under those same terms and conditions. That's fairly common. We like to get rid of that if we can, but it's fairly common. Not common at all is when you enter into a gas lease with a gas company to develop your property for oil and gas, that you are also giving that company the right of first refusal, that if a third party, whether it be a company trying to buy your oil and gas rights, or whether you're going to sell your oil and gas rights to a relative, to a friend, any third party, person or entity, you have to go to the company who holds your gas lease, the gas company, and say, hey, gas company, I want to sell my gas rights to my nephew and my niece. Here are the terms of the offer. Do you want to match it and buy the rights instead of them? That's what this is saying. I'm going to be right back. I got more to say about this, a lot more, and I only have a little left in the final segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday, again from 8 to 9. I'll be back after this break. I'm going to talk more about this. I find this very concerning. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You miss any of today's show, you can go back. PAGasleaseattorney.com, pipelineattorney.com. Have the shows posted tomorrow morning, Monday morning, as we do for many shows that are available on the websites at PAGasleaseattorney.com and pipelineattorney.com. Okay, talking about this, I don't know that I've ever seen this before, where the gas company, you as a landowner are entering into a lease with the gas company, and you believe that you're entering into a lease, and the basic deal is, you're going to give me some money up front, and your company going to have the ability to extract oil and gas beneath my property, probably operate on the surface of my property, and I have a potential of future royalties. But this goes so much further, and we see this a lot, especially in the western part of the state. This lease is saying that not only are you leasing your gas rights, but we see all the people, all the landowners who are receiving all of these postcards and offers to purchase your oil and gas rights. Again, don't do it unless we talk. But if you're considering selling your oil and gas rights, well, this lease form says that if you're considering selling your oil and gas rights, if you have an offer and you're entertaining that offer and you want to sign it, you have to go to this gas company who holds your lease and say, hey, gas company, I have an offer to sell my oil and gas rights, whether it be to one of these companies that are sending you postcards and letters all the time in the mail, whether it be to a relative, a friend, whoever the case may be, that you're considering or you're going to or you want to sell your oil and gas rights, or sell a portion of your oil and gas rights, not everything. Even if you want to sell 10%, sell it to your grandkids, sell it to whomever. You want to sell some of your oil and gas rights. Or you want to sell some of your lease rights that say, hey, I'm going to give you a right under this lease for royalties produced under this lease. Any of those type of things, you have to go to the gas company who holds your lease and allow them the opportunity to match that offer. You know, this company has now gotten into the business of, brokering, purchasing, buying oil and gas rights. Well, who in the world is going to have the best information about about a property and the value and potential value of future oil and gas rights than the company holding the gas lease. The ones who may have the seismic testing results, the ones that know everything that's going on in the industry, the ones that are drilling in the area. And so they know. Talk about a great gig. What a deal for a gas company to say, okay, we're going to pick and choose that anytime any lessor, landowner lessor wants to sell their oil and gas rights, they got to run it past us first. And we can pick and choose which ones we want to buy. Then think about that. Do you want to have the surface of your property and the subsurface of the property is owned, the oil and gas rights are owned by the gas company? What do they care about the surface of the property? Do you want to do that? I can't. This is, in my mind, my opinion, this is terrible. You don't want to have to give the gas company who holds your lease the right of first refusal whenever you want to sell your oil and gas rights to any third party, including a relative, a friend, whatever. You have to go to them. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. I'm talking about this lease form, and it's a Huntley lease form in the western part of the state, where it gives the company the ability, the right of first refusal, that if you're going to sell all or any part of your oil and gas rights or royalties for your property that's under lease, you have to notify this company and give them, and they have a 15-day period in which to decide whether they want to match that offer and purchase your gas rights. So you can say, I want to sell my gas rights or a portion of my gas rights to my nephew, my grandchildren, whatever the case may be, and all of a sudden you have to supply this information to the gas company, and they say, okay, yeah, we'll take that deal. And now you've sold your rights to the gas company and not the person you intended to. It's a great position if you're a gas company because you can pick and choose when you want to buy or not buy oil and gas rights and royalty rights that the landowner wants to sell to some third party. I don't like it. I don't like it at all. And we need to be concerned and worried about that. One of the things we see all the time is this whole idea, oh God, the old P word being partnership, where the gas company, I deal with this all the time. Oh, partnership. Yeah, it's a heck of a partnership, boy. It's a pretty one-sided partnership. Well, what you find is companies are saying, oh yeah, hey, I want to buy your oil and gas rights. We don't have to buy all, we'll buy part of them. And then we'll have this partnership where we'll be looking out for your interest, landowner, because we both own your oil and gas rights together under this property. Well, here's the deal. You own the surface of your property, and you decide that you're going to sell, and it could be any amount, but we'll just go 50% of your oil and gas rights to a company, a mineral rights acquisition company. But before you do that, you're going to talk to me. But if you do that, well, what's going to happen? Think about this. You now own the surface of the property, and a company owns the oil and gas rights underneath your property. You guys each have a 50-50 split. Let's say that the property isn't leased or the lease expires. That's a great, easy example. The company, do they care? A company or person that owns your oil and gas rights but not the surface, do they care at all what happens on the surface of the property? Absolutely not. Why would they? All they care about is maximizing profits from their share or interest in the oil and gas rights. They don't care about trying to limit what type of activity can occur on the property. They don't care about setbacks or distances from operations from your house, your water well. They don't care if the pad site goes in the best possible area of the property where you may have planned to have your children build houses in the future, whatever that case may be. All they care about is money. Don't blame them. Why would they? They bought oil and gas rights. They want to maximize those oil and gas rights. So be careful about some sort of partnership. How is this a partnership? The only partnership is that you both own a part of the oil and gas rights underneath a premises. That's the extent of the partnership. How are you working together? I don't get it. The idea, if maybe the company's not paying royalties properly, well, everybody's in that same partnership. You have that partnership with, every other person in your unit and potentially every other person in your area, with that company. So, hey, it sounds great. Oh, we'll keep tabs on the gas company. We'll keep tabs on the gas company. Well, what are you doing about the surface of my property? What if the company wants to go on the surface of my property? What if in the future we're approached for leases? I have to sign, or I'm approached for a lease for my 50% of my property. You're approached for the lease for your 50%. If you only own the oil and gas rights, look, if I only owned oil and gas rights for any property, what do I want to do? I want to, it's purely financial, get as much money as I can for the oil and gas rights, which may mean signing the most wide open lease form to allow any type of activity that the company would ever want on the property that you're authorized to do as an oil and gas rights owner. There's still limitations, but the point is you don't want to be restrictive any more than what the law requires that there's restrictions. So you don't care about the surface of the property. Be careful, landowners. If you care about the surface, what should you get in bed with? Because it's not a partnership. It's, hey, how do we maximize the money? Now, sometimes maximizing royalty to get the most royalty, well, everybody wants to do that. But what are they really doing for you? And that's a really, really big question. Really big question. So please, you got to watch out for these purchases of oil and gas rights. There are so many issues. I'm holding one of these other forms and I'm running. I'm not going to be able to get to all this. But, here's a form that, landowners send these to me all the time. And I, hey, look, if you get offers to buy and sell your oil and gas rights, you want to share them, give us a call, fax them to me, email them to me, go to pagasleaseattorney.com, send them to me. I'm always looking at these. We want to keep landowners informed, but this one cracks me up. And most of them too, frankly. But this one cracks me up. This is a great offer. This is an offer. Well, I say great offer. It gives you an idea. This is an offer, 2015. 2015, an offer for $10,000 an acre to buy oil and gas rights. $10,000 an acre to this person. Not going to name the person. Saying that this entire process can take as little as 5 to 7 business days after verifying your ownership interest and drafting documentation. Then goes on at the bottom and says, this offer is subject to the verification of your ownership and revenue from the... what? It's subject to the verification of your ownership and revenue from the subject properties to the satisfaction of this company and its affiliates. I mean, these things, they're so wide open. So you see, 5 to 7 days, I'm going to get rich. But there's loopholes galore, not to even mention the sales agreements, the deeds. You got to be careful. Considering selling oil and gas rights, call my office, 570-307-0702. I'll tell you what you need to know, what you need to be worried about, and why you need to be thinking about this maybe more than you are. But you think about all these things and it's a good move for you, well, then let's do it, and let's do it right. Because I've never been involved in these transactions where we haven't significantly changed these documents to the benefit of the landowner. I am Attorney Doug Clark. You're listening to All Things Marcellus. We got to wrap it up here every Sunday from 8 to 9 a.m. I'm going to be here next week again. Have a great week, everyone.